He worked for a law firm in New York City for several years before he rejoined the Times in the legal department. He worked as a lawyer for the New York Times for about 10 years and then joined the news staff in 2002. In 2008, he took over the Supreme Court beat from Linda Greenhouse, who had covered the court for many, many years. He also writes a regular column on legal issues, a sidebar, that appears in the Times every other Tuesday. So you might look for that next Tuesday. Is it coming out next Tuesday? His coverage of the court is lively. It's very engaging. I am a very devout reader of his work. What's interesting is he doesn't stop with just reporting the decisions, but you get a lot more context, background, because of his work. And I think that helps a lot of us to understand the people on the court, the process on the court, as well as the outcomes of the court. He also has taught media law at Columbia University and at Yale Law School. He and his wife have 2 teenagers. They live in Washington, D.C., and it is just a delight to have him come and speak to us. So, Adam Liptak.
Thank you very much, Richard, and that warm introduction was characteristic of the really lovely 3 days now that I've had visiting here. It's been a real treat to get to know the university and its students. And I thought today I would try to share with you a little bit of an overview about what the modern Supreme Court looks like, what the Roberts Court looks like, and then maybe a little bit about the cases that they're considering and how they interact with aspects of popular culture, which can sometimes illuminate the court because they're a little bit detached from regular life. And then I'm eager to have your thoughts and comments and questions about journalism or the court or anything else. But let me start by giving you a sense of who the justices are today, because we're at a very odd moment. We have a very different court than we've had even a few years ago. We now have, for the first time in a century, and I guess I'd have to say this is not a good thing, justices who are perfectly aligned by the ideology of the president who appointed them. That is to say, historically, you wouldn't know for sure which way a justice was likely to vote just by looking at the president who appointed that justice. But today, for the first time in a century, the 4 more liberal justices were all appointed by Democratic presidents. The 4 more conservative ones all appointed by Republican, the 5 more conservative ones all appointed by Republican presidents. And I think as we go into just a couple months from now, the arguments in the big healthcare case and the decision in June, which conceivably could be a 5-4 decision split along those same lines, those partisan-looking lines, perhaps striking down the healthcare legislation, that's probably not the image the court wants to project. The court likes to think of itself as not involved in politics, not influenced by ideology, but rather simply, as Justice Sotomayor said at her confirmation hearings, simply applying the law to the facts. But it turns out when these justices apply the law, the same law, to the same facts, they come up with different conclusions, typically spread across this ideological spectrum. So that's probably not a great thing. And just to tell you how that's a contrast to even recent history, consider the last 3 justices who left the court. Justice John Paul Stevens left the court about a year ago at the age of 90, after serving for more than 30 years. And he was the leader of the liberal wing of the court, and yet he had been appointed by a Republican president, President Gerald Ford. Gerald Ford, back in that day, wasn't looking for somebody with a political tilt of any kind. He said to his staff, get me the best lawyer you can find, get me the best judge you can find. And he found John Paul Stevens, and would later say about Stevens, and I think this is very much to Gerald Ford's credit because they weren't ideologically entirely compatible. He said that Ford said he would stake his entire reputation on that one part of his administration, the appointment of John Paul Stevens. Before that, a year before that, David Souter left the court. David Souter, also a member of the court's liberal wing, but appointed by the first President Bush. I don't know whether President Bush was disappointed in what was perceived to be a drift to the left by David Souter, but across this kind of predictability independence spectrum, I think you have to say it's a good thing that you can't predict perfectly how a justice is going to vote. depending on the politics of the appointing president. And then the resignation before that was Sandra Day O'Connor. She was a moderate and in her later years drifted left and appointed by President Ronald Reagan. So you could look at the court over the last 40 years and see a lot of scramble, have less predictability. And again, the point I want to make is that I think the nation would be better served if we didn't have such a strong connection. But it does seem that in recent years, and this goes with both kinds of administration, that they seem to have cracked the code about how not to be surprised, how not to see ideological drift from the justices. So you know the two Obama appointees, Justice Elena Kagan and Justice Sonia Sotomayor, were the two justices the last term who voted together more often than any other pair of justices. So that's very suggestive that President Obama knew precisely what he was getting. The two justices who vote, the next pair of justices most likely to vote together were the two George W. Bush appointees, Chief Justice Roberts and Justice Alito. So there, too, they seem to have cracked the code. I think part of the reason that's true is, and I'll talk about this a little bit, is because presidents tend to appoint sitting appeals court judges, so you have a very good idea of where they are jurisprudentially. You can read their decisions. And very often these days, you get people appointed not from New Hampshire like David Souter or from Chicago like Justice Stevens, but from Washington, people who are well known to the appointing president, people who have worked in the Justice Department and the White House, and you've gone to lunch with them, and you really know where they are ideologically. So I think we're in a different era that way. We also have a court that is in some ways quite diverse. We have 3 women on the court, and I'll tell you, the image of 3 women on the court, which just started last term, gives the courtroom a different kind of feeling. And it's hard to put it into words and why it should matter. But when the big employment discrimination case brought against Walmart was argued, you had a sense that there was a different dynamic in the room. Justice Scalia has reflected on this, that at their private conferences, back when Justice Thurgood Marshall was part of the court, the first African-American justice, Justice Scalia, conservative justice, would say, you know, anytime race was discussed at our conferences, Justice Marshall wouldn't have to say anything, but the fact that he was in the room made everyone think about the topic a little differently. So that kind of diversity we have on the court. We have with Justice Sotomayor, the first Hispanic justice, and with Justice Clarence Thomas, the second African-American justice. That kind of diversity we have. But in other dimensions, we've moved in a different direction, and it's sort of interesting, and I'm not sure what to make of this. I don't know how many of you have focused on the fact that for the first time in American history, there is not a single Protestant on the court. There are 6 Catholic members and 3 Jewish members, and the fact that it's not much commented on is probably a sign that we've moved past that. It used to be very much the case that there was a Jewish seat, a Catholic seat, and presidents would work hard, if one of them retired, to find another Jewish or Catholic justice, but not more than one, typically. There's an exception. If you can get both Brandeis and Cardozo on the court, you might settle for 2 Jewish justices. But this seems to be a fact we've moved past. It was also the case that until quite recently, presidents worked very hard to make sure there was geographic diversity, that there were justices from the West and justices from the South, and that was very much part of the thinking. But with the departures of Chief Justice Rehnquist and Justice O'Connor, who were true Westerners, who really knew and cared about the West and the issues of the West and water rights, and also were strong Federalists in the sense of caring about state sovereignty, we have a different kind of court. We have a court that's very heavily tilted toward the East Coast. We have what I call justices from the Acela Circuit, meaning the fast train that runs between Washington and Boston. We have 4 justices from New York City. New York City has 5 boroughs. 4 of the boroughs are represented. You may ask whether that's exactly what you want in the court, whether you might not want more diversity, people knowing a little bit more about the whole country. And then finally, and maybe to my mind most importantly, we have a lack of diversity in this sense. We have a court that is extremely highly credentialed. Every single one of them attended Harvard or Yale Law School. Think about that for a second. There are a lot of great law schools in this country. Those are good law schools, but they're not the only good law schools, and they imbue in people a kind of East Coast elite thinking, and that every single one of them attended just 2 law schools. Now, it's true that Justice Ginsburg started at Harvard but followed her husband and graduated from Columbia, but the general point holds, I think, is problematic. They are also with the exception of Justice Kagan, who was nominated to the D.C. Circuit, the Federal Appeals Court in Washington, but not confirmed, every single one of them had been a former Federal Appeals Court judge. That is a brand new phenomenon. It used to be that the court attracted people who had large public life experiences, political life experiences. The court that decided Brown against Board of Education, the landmark decision outlawing segregation in public schools, had on it a former governor of California, a former United States Attorney General, a former United States Senator, the leading law professor in the land. So I'm thinking of Earl Warren, Robert Jackson, Felix Frankfurter, and Hugo Black. That's a very different mindset. That's not the only thing you want on the court, but it might be good to have someone like a Sandra Day O'Connor, who's a very good judge, but had served in all three parts of the Arizona government, had been in the state Senate, had served in the executive branch, and had been a state court judge. And you bring a lot of life experience to the court. If you're a former federal appeals court judge, 4 of them are former law professors. Many of them seem a little remote, even from trial work. Justice Alito and Justice Sotomayor have some trial work, and you can see in their decisions that they understand a little bit the texture and mechanics of what actually happens in court. So you have a court now that's a little, very, very technically able. Walter Dellinger, the former acting United States Solicitor General, used this phrase, which I quite like. We have a court of logicians. They're really good at figuring out how various propositions fit together in a logical manner, but some have suggested that maybe they don't have quite the real-world experience that that justices of an earlier day may have had. So let me give you a sense, and the court's work on the whole is very technical and dare I say even a little boring. So the challenge of a Supreme Court reporter like me is to try to turn that legal, technical, jargony stuff into accessible journalism, and also to try to illuminate the court in various ways. And one way I think is fun to think about the court is what happens when they do find themselves engaged with popular culture. I've just described how they're a little remote, almost a kind of pre-bureaucrat, here's a mixed metaphor, a bureaucratic priesthood, withdrawn from life. But sometimes they don't have a choice but to deal with cases that may be a little bit more fun, and I think it's interesting to see how they come at them. So let me give you a little vignette from just earlier this month. They're considering a very significant First Amendment issue, and this is a court that has been fairly strong on First Amendment stuff. You may disagree with them, but they have allowed hateful protests at military funerals. They've allowed the distribution of videos showing animal cruelty. They've struck down a law that would have barred the sale of violent video games to minors in California. And of course, in Citizens United, they've allowed corporations and unions to spend unlimited funds from their general treasuries on political advertising and other kinds of independent expenditures. So this is a court that cares about the First Amendment. And the First Amendment issue that was at issue earlier this month in a case called Federal Communications Commission against Fox television stations was whether it still makes sense to allow the government to regulate broadcast TV and outlaw cursing and partial nudity. Start with the idea that in general the First Amendment says the government shouldn't regulate speech. And then remember that on cable television, including cable, non-premium cable, and the internet, the government, everyone agrees, cannot regulate what's on the internet and what's on cable TV. But why is broadcast special? And there used to be a rationale for this that was very persuasive, but I think about whether it remains persuasive. In 1978, there was a famous comedian named George Carlin who went on the radio at 2 o'clock in the afternoon and delivered a very filthy but very funny monologue that people refer to as the 7 dirty words monologue. And some poor guy is driving around with his son in the afternoon and comes on the radio, and he found it very offensive. And the radio station gets fined for this. And the Supreme Court says that's okay. We're going to allow regulation of broadcast, their radio, but also television, because it's uniquely pervasive and uniquely accessible to children. So the question today, though, is, does that still make sense? Is TV that comes in over the air still unique, given that when you flip around on your cable dial, 3 channels are regulated by the government and 297 channels are not, and the internet is not? And does that make sense? Now, this arises, and you got to love this because it's such a disconnect, in the following context. it turns out that many celebrities, including Bono, Cher, Nicole Richie, and Paris Hilton, can't seem to accept an award at the Golden Globes or the Billboard Music Awards without using the F word. You know, they get excited, and I'm not sure the reference is sexual, but they say it's effing great or something like that. And the question is, does it still make sense to allow the government to impose a sometimes quite large fine on this station that fails to bleep that out fast enough? Similarly, there's a question about whether NYPD Blue, some of you probably don't even remember that show. It was a pretty good cop show, and it would occasionally, you know, try to go up to the line of what's indecent on broadcast television by showing someone, you know, sort of naked from the side and behind. This case had been before the court once before, and that's not unusual at all. The court often chews on an issue, comes back to it, kicks the can down the road. And in 2008, the government's lawyer said, his argument I really quite enjoyed. He said, the world that the networks are asking you to adopt here, where the networks are free to use expletives, could include the extreme example of Big Bird dropping the F-bomb on Sesame Street. But that was 3 years ago, and they kicked the can down the road, but now they really have to try to figure out how they're going to address this. And on the one hand, there were justices, including ones who are ordinarily very good on free speech. The Chief Justice Roberts and Justice Scalia said, listen, it's not the worst thing in the world to have a protected zone, an island that you can go to reliably and not be assaulted by the vulgarity of modern life. But you also had Justice Ginsburg, who criticized the FCC for being arbitrary and not really, it's hard to tell what's allowed and what's not. So she said, one cannot tell what's indecent and what isn't. And I think she has a point, because the commission has, the FCC has, for instance, said that swearing in the Steven Spielberg war movie Saving Private Ryan was okay, but swearing by blues musicians in a documentary directed by Martin Scorsese is not okay. And that nudity in Schindler's List, another Spielberg movie about the Holocaust, was okay, but a few partial seconds of nudity on NYPD Blue was not okay. And Justice Kagan, who's been a real great addition to the court, tried to synthesize, tried to analyze where does that leave the law. And she says, the way that this policy seems to work is that nobody can use dirty words or nudity except for Steven Spielberg. Which is an accurate description, but I'm not sure that's exactly what the founders of our nation, meant to achieve. I've also been following quite closely the work of the Roberts Court in a phenomenon you probably haven't focused on, the citation of rock music in Supreme Court decisions. This came up just a few months ago. In October, the court heard a case, actually a very important copyright case, about whether once materials have entered the public domain, that means you and I can use them for free and adapt them and so on, can Congress pass a law that restores copyright protection to stuff that had entered the public domain. And Justice Ginsburg, who's 78, uses this frame of reference. She says, could Shostakovich have been treated just like Aaron Copland? I go, okay, that's not my world, but I guess I sort of see the point. But Chief Justice Roberts, who's only 56, he thinks about it this way. Well, what about Jimi Hendrix? He has a distinctive rendition of the national anthem, and assuming the national anthem is suddenly entitled to copyright protection, before that, he can't do that. So I think we've moved from classical music to Jimi Hendrix, and I think Roberts is really leading the vanguard on this question of the citation of rock music. Roberts had served, now Chief Justice, has been for 6 years, had earlier in his career as a young lawyer served as a law clerk to the previous Chief Justice William Rehnquist. And Rehnquist was also old school. He liked light opera. He put gold stripes on his black robes, the only justice to my knowledge who's ever done that, because he saw that in a Gilbert and Sullivan light opera and he thought it looked cool. Now, Chief Justice Roberts, by contrast, broke new ground a couple of years ago by citing Bob Dylan. The Dylan citation came in an achingly boring dispute between payphone companies and long-distance carriers. And 4 pages into that decision, I'm going to read you just a sentence from the decision so you can feel sorry for me, because this is the kind of stuff I read all day long. But 4 pages into the decision, he writes a legal proposition, and then what you typically do is after that you put some cases to support the proposition you just set out. So here's the proposition. The absence of any right to the substantive recovery means that respondents cannot benefit from the judgment they seek and thus lack Article 3 standing. Okay. And then here's what the Chief Justice writes, quote, "When you got nothing to lose, Bob Dylan, Like a Rolling Stone, Highway 61 Revisited, Columbia Records, 1965. So this seemed groundbreaking to me, and I consulted Alex Long, who's a law professor at the University of Tennessee, to put this in context for readers of the New York Times, because that's my job. I put things in context. Professor Long is perhaps the nation's leading authority on the citation of popular music and judicial opinions. He said this was almost certainly the first use of a rock lyric to buttress a legal proposition in a Supreme Court decision. It's a landmark opinion, he said. By the way, according to a study he conducted, Bob Dylan is by far the most cited songwriter in the lower courts. He's been quoted in 26 opinions. Paul Simon is next with 8, although it's 12 if you count Simon and Garfunkel, and Bruce Springsteen has 5. Now, I'm sad to say, though, that the Dylan citation is problematic. On the one hand, he showed excellent taste. Like a Rolling Stone, the critic Greil Marcus has written is the greatest record ever made, perhaps, or even the greatest record that ever will be made. On the other hand, Chief Justice Roberts got the citation wrong, proving that he is neither an originalist nor a strict constructionist. What Dylan actually sings, of course, is when you ain't got nothing, you got nothing to lose. He left out the ain't. Now, it's true that many websites, including Dylan's official one, reproduced the lyric as Chief Justice Roberts did, and I imagine his law clerks went and checked on the lyric sheet or on the website or something. But a more careful Dylanist might have checked his iPod. Let me tell you about just one or two more cases along these lines, because I think Justice Alito was emboldened by Chief Justice Roberts' experience, and he actually went the Chief Justice one better. And this decision actually has a Utah aspect to it. It arose in a case from Utah where a religion called Summum got the idea that it wanted to place a monument to the 7 aphorisms of its religion next to a 10 Commandments monument in a city park in Utah. I think in a town called Pleasant Grove, but I wouldn't swear to that. Yeah? Pleasant Grove. And the question in the case was whether the 10 Commandments conveyed a religious message, or only a religious message, or also a historical message, or whether the government, could go ahead and have this, make the decision that the 10 Commandments monument could stay, but they weren't going to have the 7 aphorisms of Summum. And Justice Alito, who must have taken some French literary theory in college, tried to demonstrate that it did not. But he's a lawyer, so he used an analogy. Here's how he put it. What, for example, is the message of the Greco-Roman mosaic of the word imagine that was donated to New York City's Central Park in memory of John Lennon? Some observers may imagine the musical contributions Lennon would have made if he had not been killed. Others may think of the lyrics of the Lennon song that obviously inspired the mosaic and may imagine a world without religion, countries, possessions, greed, or hunger. Justice Alito then dropped a footnote, again, I think inspired by the Chief, quoting the complete lyrics of Imagine, the song, and concluding Jay Lennon, Imagine on Imagine, Apple Records, 1971. Now, Justice Alito may well have been correct that you never can tell what words mean, but that's a curious position for a judge to take. Judges, after all, spend their days making pronouncements about what statutes and the Constitution mean. There was another notable Alito trend recently. He seemed to have developed a fixation with cable television programming. In an argument last October, excuse me, in the case I mentioned about whether the federal government can make it a crime to prohibit the sale of depictions of animal cruelty. That is, animal cruelty itself is illegal, but can you sell a video about a dogfight? The answer turns out to be that law is unconstitutional under the First Amendment, but that's not the point I'm trying to make. At the argument, Justice Alito was spitting out hypotheticals, analogies. That's how a Supreme Court argument works. Well, what about this, counsel? And he says, people here would probably love to see it. What about a human sacrifice channel? Would that be okay? Live, pay-per-view, on the human sacrifice channel. Yeah, that's $1 million idea right there. 3 months later, in an argument over whether the government owns newly restored beaches that had been threatened by erosion, Justice Alito worried what would happen to the former beachfront property owners. He said, you could have televised spring break parties in front of someone's house. So another $1 million idea. You have the Human Sacrifice Channel, the Spring Break Channel, and I think that if Justice Alito ever thinks of stepping down, which I'm sure he won't, they seldom do, he could think about a career in cable television programming. But let me go back to music for 1 second. The last citation I want to talk about came in a case about a hot new technology that just reached the court a year ago. It involved pagers, and that gives you a sense of how slow the court is legally to catch up to advances in technology. Now, I should say that just earlier this week, the court issued a major decision on GPS devices, and those are perfectly current technologies. And in a very interesting decision, the court started to suggest that modern surveillance techniques might require a new understanding of the Fourth Amendment. So I'm not here only to mock them, but perhaps partly to mock them. So anyway, in this pager case, the question was whether members of a police SWAT team in California who seemed a little dim because they were sending sexually explicit text messages on their government-issued pagers to their wives and girlfriends, and often the same person to their wives and girlfriends. The question in the case was whether the government was allowed to inspect these government-issued pagers for these private communications. And the majority said it was wary of deciding anything because things were moving so fast. Justice Scalia often pushes to say, listen, our job on the Supreme Court is not only to decide the particular case, but it's also to give guidance to lower courts, to tell lower courts what the rule is. So from here on in, they can say, what in the next case the answer should be. And so he wrote, quote, the times they are a-changin' is a feeble excuse for disregard of duty. Now, there wasn't any citation there, but I think you can agree with me that we can chalk up one more for Bob Dylan on that one. Now, I think I'd like to leave a good amount of time for your questions because it's such a rich topic and there's so many ways to come at it. And I'm sure you have lots of questions about the court, the justices covering the court, the New York Times or whatever. So why don't we turn to those? I see there's a microphone in the back.
You started your discussion by talking about how we have a very ideologically divided court, and not
Yes.
only that, but you can predict it by the president that appointed each justice. And it seems to me throughout history, we've had basically two competing legal philosophies on the
Yes.
Supreme Court, broadly originalism and broadly a sense of living constitution, evolving standards of decency, et cetera. In your opinion, are these legal philosophies simply a facade for ideology that allows the justices to reach legal conclusions that they prefer ideologically, or are they truly coherent legal philosophies that are followed regardless of the ideological end that they desire to achieve?
That's an excellent question. So let me start by saying that originalism, meaning an effort to understand what the framers of the Constitution meant when they used certain words and phrases, is actually a relatively recent way to deal with constitutional interpretation, certainly as an exclusive matter. And you can trace it back to Hugo Black, a generally liberal justice, but it certainly comes into its prime with Justice Scalia. And it is a philosophy that perhaps incidentally or perhaps on purpose generally produces conservative results, but not always. And I am admiring of Justice Scalia to the extent he takes the view that his job is to be bound by, it may not be the right mode of constitutional interpretation, but certainly it's appealing when someone says, here's my theory, I'm bound by that theory, and if it takes me to a result I don't like, my job as a judge is to go there because this is my theory. So Justice Scalia certainly is no fan of flag burning, but he says the original understanding of the First Amendment should allow flag burning as a form of symbolic political protest. He's not an especial fan of criminal defendants, but in cases involving say, crime lab testimony, where prosecutors just want to put in a piece of paper saying the crime lab shows that you had drugs in your possession. He says that's no good because the confrontation clause of the Constitution requires criminal defendants to be able to confront and cross-examine the people accusing them. So there he's willing to follow his theory to a place that probably does not align with his policy preferences. And a third example is he has been a real proponent of a revolution of making sure that juries are involved in sentencing decisions, that they actually find the facts that increased sentences are based on. And there, too, I'm not sure that if he was on a legislature, that's what he would vote for. But on the bench, he does follow his theory, even when it probably conflicts with his policy decisions. And I think to that extent, originalism is attractive in that limited sense I've been talking about. The living Constitution, unconstrained by any kind of theory, is problematic because it places much too much discretion in the preferences of individual justices. But I don't think any current justice would say, hey, my job is just to figure out what's right. They would say, we're going to look at that same text, at that same Constitution, but maybe try to intuit from it not so much what people in 1789 thought, but what the modern meaning of that value in there means today. And to look at the text, to look at context, to look at purposes, look at consequences, and still constrained, but perhaps not as heavily, come to a conclusion. You've seen an interesting debate lately between two conservative members, Justice Scalia, who I've just described his approach, and Justice Alito, also conservative. I don't think he'd say he's a living constitutionalist, but he would say he's a pragmatist. And an argument over violent video games, there was this great back and forth where Justice Alito says, I think what Justice Scalia wants to know is what James Madison thought about violent video games. And that sort of tweak tells you that this document, even if we're able to unearth what people at the time thought, it's very hard to apply that to video games or GPS or whatever else. Now, Justice Scalia came back and said, no, I want to know what they thought about violence, whether the depiction of violence was something the First Amendment would ever allow the government to regulate. So in a way, they're both right, but they're coming at the same document from a different level of abstraction. What was the original intended consequence at the time? What's the value the founders were trying to promote? I'm sure there are more questions. Yes?
You mentioned how split the court is along ideological lines. Would you just comment on to what degree do you think the Federalist Society plays an influence in this?
The Federalist Society, as I'm sure you guys know, is a very influential, relatively recent Ronald Reagan era group that tried to promote in a generally liberal legal academy, and the law schools in general are quite liberal, attention to conservative values. And among the things that it did was to try to place more conservative lawyers as law clerks, and led in large part by Ed Meese, Ronald Reagan's Attorney General, to put more conservative judges on the federal courts, and has been very, very successful. And I think it's the case that most Democrats would agree, Republicans care more about the courts. Republicans are eager to drive back what they see as some of the excesses of the Warren Court, a liberal court, and Democrats like Bill Clinton and Barack Obama have not worked as hard to put people on the lower federal courts, and at least by historical standards, their nominees have been relatively moderate liberals. So I think in all those senses, the Federalist Society has both changed the terms of the debate, has brought originalism into the debate much more, and has really focused on cultivating very capable and able young lawyers, law professors, and judges in a climate, to be fair, where they're working in a legal academy which very heavily tilts left. So when you look at surveys of, say, campaign contributions at the elite law schools, 95% of them at Harvard, Yale, and Stanford go to Democratic candidates. Yes? You want to wait for the mic? I'm sorry.
Maybe you could talk a little bit about your personal relationship with the justices and how much access you have to them personally.
I have limited and almost entirely social, and to the extent it happens, quite collegial relationships with the justices. The justices properly are constrained not to talk about pending cases. The court is a small community, so you can't help but running into people at functions and so on. And when I started on the beat, I made the rounds, and people were quite welcoming. But it's not a newspaper beat like most newspaper beats. Most of my colleagues in the Washington Bureau of the New York Times really work hard to cultivate relationships and get access so they can find stuff out that's secret. I do almost none of that. In that sense, I'm barely a journalist. I'm really an analyst, an explainer, someone who on a tight deadline tries to convert complicated legal materials, whether arguments or decisions, into, I hope, accessible newspaper articles in the Times. So that kind of access journalism is not what I do. And while I am friendly with and admiring of all of the justices, the interactions I have with them don't really inform my work at all. What informs my work is trying to keep up with the decisions, the briefs, the enormous volume of stuff that comes through, and the really excellent advocacy the court sees.
Since we're at a religious institution,
Yes.
I was wondering what you foresee as the future of religious arguments in the legal sphere in general. I know that you did talk about the case from Pleasant Grove, and there are a few other groups that like to use religious arguments, and I was just wondering if you see that failing as a legitimate argument or not.
So let me draw a distinction. To the extent the argument is based on religious principles, I have no particular reason to think, and Justice Scalia, for instance, will say the fact that he's a Catholic does not influence his decision-making. So I don't think religiously based arguments, there may be exceptions, but I can't think of one offhand, are going to have, or in my view should have, traction in a culture that is based on law. But a slightly different question gives a different answer, which is that this court does seem very sensitive to religious freedom and open probably more than previous courts to an increased role for religion in public life. And the court unanimously, the court has issued a couple of unanimous decisions lately, which cuts against the point I made at the very outset. Unanimously, just the other day, held that there must be a ministerial exception to employment discrimination laws. So if a church chooses to fire someone, say, who has some kind of role in spreading the faith message of that church or synagogue or mosque, the government cannot impose employment discrimination laws on that church and say, you can't fire that person because that violated a disability discrimination law or something. And the fact that the court was unanimous and strong on that point made you think that they're very sensitive to making sure there's a place in American life for free exercise of religion.
I was just wondering, what do you think some of the most significant cases coming up on the Supreme Court docket are?
Great, and I probably should have talked about that even without being prompted. It's a big, big term. Without question, the biggest case of the term, and maybe the biggest case since FDR's time, is the confrontation between the Obama administration and its signature piece of legislation, its proudest achievement, the health care law, and the Roberts Court. And we're going to have 5.5 hours of argument in that case. 5.5 hours. We usually have 1 hour of argument in a case. Haven't had that long an argument since the 1960s. So you have the sense that we're on something really big. The question in the case is whether Congress was entitled, because Congress can only do those things which the Constitution allows it to do, whether Congress was entitled either under either its power to regulate commerce or its ability to tax, to insist that people either obtain insurance or pay a penalty. And that's a very significant question, and you can tell by the 5.5 hours that it's going to be a big, big deal. So if the term had nothing else in it, it would be a big term. But we also have a case about whether Arizona was entitled to pass very tough anti-immigration laws. We've already had the GPS case, which I mentioned in passing, the ministerial exception case. We've had a case where the court rolled up its sleeves and got into congressional redistricting in Texas. There's a case about whether corporations can be sued for assertedly engaging in torture abroad. There's a case about juvenile life without parole. It is a very rich term. In fact, I reflect sometimes this is my 4th term, and I've had a learning curve, and I feel a little more confident now than I did when I started on my first day. Thank God this wasn't my first term, because it's one big case after another. Very, very, very rich term. And if you're interested in hearing more about any of those things I rattled off, I'm happy to talk about them. But let me not, make this into a law school class and make sure I get to your questions.
Hi, I'm Kelsey Clark.
Hey.
My question is, what is your commentary or insight into the debate going on right now about allowing cameras into the Supreme Court cases during oral arguments?
Sure. So I'm here in part to participate in a symposium over at the law school, co-sponsored by the Communications and Political Science departments, and this has been a very hot topic over several days. I will first of all disclose to you my very strong opinion that I don't see any principled reason to keep cameras out of the court. I think it's very important for American citizens to be able to see their government at work, and I don't really get the counter-arguments, or to the extent I get them, I don't think they're legitimate. I think what really drives the justices, let me see if I can, first of all, they're conservative, not in the political sense, but in the sense that they're custodians of a very highly respected institution. The Supreme Court's approval rating is very high compared to Congress, the president, journalists, lawyers. I mean, people respect the court, and the justices are wary of anything that would bring disrespect upon the court. My own view is that if people saw just how smart and able and careful and in command of the facts and the law and the record in the case these public servants are, they would be delighted to see that there's at least one branch of the government that really does its homework and really does its work. And I think it would increase the reputation of the court, not decrease it. I think the justices are a little bit scared that in the era of Jon Stewart and Stephen Colbert and YouTube, when they say something goofy, and they do, bless them, they do say the occasional goofy thing, that will somehow expose them to mockery of some sort. There's some, that's not crazy, but that's not a principled argument against allowing cameras. I find that the argument that moves me the most, and one I hadn't thought of until I started covering the court, I try to write all kinds of different stories about the court and not just about what goes inside the building. So one night, before a big argument in a Second Amendment case, I hung out all night with the people who stand on line to get into the court. So pause for a second. We make people stand in the winter outside all night long in order to see the government at work. And I hung around with some junior high students who were very excited about this and wanted to get in, and there are 50 seats in a big argument available to the general public. I'm not sure all of them got in. So we make American citizens sit outside in the cold for a chance to get to see their government at work. That doesn't make any sense to me. That would seem to me to require a very good justification for why we do that. You occasionally hear, and we heard at the conference, not a lot, but you occasionally hear the argument that, well, what would it really add? People can read the transcript. People can now at the end of the week get audio. It might give people a misimpression that this is the most important part of the work, where in fact most of the work gets done in writing. It might allow the justice to be sound-bited. All of those arguments strike me as paternalistic. I think we should let people see what their government does. And it also occurs to me that it's hard to say exactly why it's different, to see it in action, to see the tone of voice, to see the body language. But I would never in a million years think about writing a story about a Supreme Court argument based on the transcript. I wouldn't think I would know enough. I wouldn't think I could actually hear whether a question was sarcastic or straight. So, you know, perhaps some of you have idea. I'm pretty dug in on this, and maybe I've lost my bearings, but I really don't get it. That said, it's a wholly academic discussion. They're not going to let cameras in anytime soon. They seem pretty dug in the other way, and so sometimes I wonder if we spend too much time talking about something that's not going to change. But as you can tell, my own view is there's really not there's not a reason not to allow cameras. And I say this also against my self-interest. It's probably good for me professionally to be the intermediary because you can't watch it yourselves.
So Clarence Thomas's wife has been associated with a lot of conservative causes, some of which will be before the court in this next session. How will that influence his judicial opinion making, do you think, during the upcoming session?
Clarence Thomas is a little hard to read. He hasn't asked a question in more than 5 years. But I don't think in a million years his thinking about the healthcare or any other case is going to be influenced by the political activities of his spouse. And I think in the modern era, it would be a grave mistake to require the disqualification of a justice simply because a spouse has an opinion. It would be different if she had a financial stake in the outcome of the case, but I don't see that. And I don't see any serious professor of legal ethics thinking it's even a close question. Now, might it be more prudent? Might it reflect better on the court? And this is not just the point about the conservatives, for people to step back a little bit and not be out and about, and perhaps for families not to be out and about quite so much. Maybe so, but I don't see a legal ethical question. There's a similar argument on the other side that Justice Kagan should be disqualified from the healthcare cases because people think she may have played some role in the early defense of the case when she was the government's top appellate lawyer, the Solicitor General, before she joined the court. There again, I don't think we've seen any evidence that suggests that we can't take her at her word that she walled herself off from that immediately. But that may actually be the harder question. If in fact she played any role at all, the federal statute in this area would require disqualification. There's also a statute that requires disqualification if you have any financial stake in the case, and if Clarence Thomas did that, then that would require disqualification. And then there's a more general ethical rule that you have to disqualify yourself if a reasonable person would think you had an appearance of a conflict of interest. And that's a little mushy, and I'm not quite sure what to think of that. But most people say that that would require a reasonable person in possession of all of the facts to make a reasonable judgment. At the end of this last year, the Chief Justice issued what is usually a very boring report on the state of the judiciary, but he chose to talk about these issues. And he very strongly suggested that they can be trusted, that there's no reason to move away from the current regime where justices get to decide for themselves whether to disqualify. That seems a little odd, doesn't it, that the judge gets to be the judge in his or her own case about whether to be disqualified. But he came back with a very strong point, which is, what's the alternative? Are you going to have the whole court decide that someone can't sit? And wouldn't that give rise to some very problematic gamesmanship, where what if a majority of justices decided to knock some people off the case because they were afraid of how they might rule? So it would have real costs in collegiality and might have really more significant costs yet.
Maybe one last question, if there is one. And then we need to stop.
I guess I'm curious more about the personal aspect you experience as a journalist. So I was wondering, how has covering the Supreme Court changed you as a person and as a journalist? Has it changed your value system or the way you look at the government or the way you interpret the world in any way?
That's an interesting question. The immediate answer I have is that it has changed me in this regard. I practiced law for 15 years, and there were parts of the law I got to know pretty well, particularly the First Amendment. But the Supreme Court beat has caused me late in life to have a forced march, to really start to understand fairly deeply, because you really spend a lot of time, struggling with difficult religious freedom or Fourth Amendment issues. So it's like going back to law school, is what it feels like. It probably increases my respect for the high end of the legal profession. I hold the legal profession in fairly low regard, but the lawyers who appear before the court are really first-rate advocates. The justices, whatever you think about my initial point about ideology, are very, very capable, able jurists. So it increases my respect for them. And, coincident, I had lived in New York City for 20 years before moving down to Washington. It also gave me even more reason to be cynical about the balance of the government in Washington, which these days really is not in great shape. So I hope that, I wish I could give you kind of a more emotional kind of response, but that's all I can do. Thank you so much for having me. I really enjoyed this.